Joshua Andrews appears as counsel for Heather Larson, who appears to be appearing in his office. Deborah Thompson is appearing on behalf of Tim Larson. The matter before the court is a motion to modify a temporary order in the case in regards to a spousal support order that this court had earlier made. Are you still pursuing your motion to modify at this time, Ms. Thompson?
Yes, we are, Your Honor.
All right. How do you wish to proceed?
Um, I could go ahead if the court is so inclined to do the argument, but if not, I would ask for the court's permission to wait just a couple more minutes to see if my client arrives before I start the argument.
Well, the problem is that his time frame for arrival is uncertain,
Yes,
and I really want to move forward with this. I want to make sure Mr. Andrews has appropriate time to respond, though
sure.
I am aware of his response to motion to modify temporary orders that was filed back on August the 11th. So, Ms. Thompson, why don't you go ahead and start your argument in support of your motion?
Okay, thank you, Your Honor. May it please the court, Mr. Larson is requesting today that the court modify the temporary orders in this matter to change the spousal maintenance so that he not have to pay spousal maintenance anymore moving forward. As the court's aware, temporary orders on July 3rd ordered him to pay $2,500 a month for spousal maintenance, and he was ordered to start paying that on July 1st, 2025. However, the petition was filed on July 1st and a summons was issued on July 8th, and Mr. Larson was not served until after that. So as a preliminary matter, no matter whether or not the court agrees to modify or not, we would ask if the court is inclined to keep spousal maintenance ordered that it state that the maintenance payment not start until August 1st of 2025. So that would allow him to have not missed a payment for July. The main reason, however, that Mr. Larson should not have to pay anything in spousal maintenance is due to the fact that there are four reasons. First, petitioner lists in her expenses in her DRA that she owes or has about $1,245 each month that she has to pay. And she's, of course, requested well above that by about $1,300. And so I believe she has greatly overstated her needs in the request. Second, the petitioner has access to joint banking accounts of the parties that have more than $49,000 in total in them. And this includes a savings account that has at least $34,000 in it. All of that is more than enough for her to utilize to pay her monthly expenses while the matter is ongoing. Third, there's no evidence that petitioner has actively sought a job. Mr. Andrews may make us aware of something different to that when he makes his statement to the court. And I would let the court know that Mr. Larson is now here with me as well.
Hello.
And so we are asking that she not be awarded spousal maintenance because she's more than capable of obtaining a job. And in fact, any job at minimum wage would provide her a monthly income greater than what she lists her expenses at. But fourth and most importantly is this joint investment account that the parties have that receives dividends on a semi-monthly basis. Ms. Larson has claimed in her response to our motion that she didn't have knowledge of the joint investment account, that it received dividends until just very recently. And frankly, this just belies credibility. Ms. Larson, the petitioner, has had full access to that account with her own login and password since the day the account was open. She has authority to move the money in the investment account to a joint banking account to pay for bills. And in fact, this was typically done during the marriage by Mr. Larson. Ms. Larson did not do it because she entrusted the finances to him. However, the money from the dividends was used to pay marital bills. It was used to pay for vacations, for taxes, and for other expenses. And the money was reinvested at one point into some stocks, but that has not been done since 2023. So the fact that she's stating in her motion that she didn't know about this while identifying that the dividends come from Brazilian oil stock doesn't really compute. In fact, it's my understanding that Ms. Larson told Mr. Larson when they were getting a divorce that she wanted the investment account because of the great dividends that it pays. So in the motion, we are asking the court to order her essentially to access that money to use as her monthly income for her expenses, if nothing else. even though there is another source for her in terms of the joint banking accounts. The petitioner also stated in a response that she had just recently found out about this account, but her DRA that was filed on July 1st lists the account and lists a full value of $645,658.07, which is a very specific number for someone who didn't have knowledge of it. So I think that the average monthly income from those dividends, which typically is in the thousands, for last year, it averaged about $4,800 a month. And it gets deposited, like I said, 8 times during the year. And so she would have access that she already has to take that dividend money that's coming in, move that over to a joint account or whatever account she wanted to set up for that, and then use that to pay for her expenses and her groceries and anything else that she's listed as her expenses on her DRA. And the argument that this would somehow deplete the marital assets, I just don't think flies, because as the court's aware, spousal maintenance is not a right or an entitlement in Kansas. It's inherently transitional. And when the parties' assets suggest that both have the means to support themselves through their joint assets without spousal maintenance, it's a fair question for this court to ask whether spousal maintenance is even justified at all. In fact, I think it would create a windfall for Ms. Larson to get spousal maintenance, because she would be getting the income monthly that is coming out of my client's paycheck, in addition to what she would eventually recover from the marital estate and when the assets are divided. And so in sense, getting dual payment for those amounts. So for all of those reasons, we don't believe that spousal maintenance is needed or justified in this matter. And we ask that the court order and change the temporary orders so that Mr. Larson is not ordered to pay spousal maintenance. Thank
Has
you,
he
Your Honor.
paid anything in spousal maintenance since the court issued temporary orders?
Yes, he made a payment in August for the $2,500 that was ordered.
All right. Anything else at this time, Ms. Thompson?
No, Your Honor.
All right. Mr. Andrews?
Thank you, Your Honor. Your Honor, I'll attempt to address Ms. Larson's points in order. First, with regard to the expenses, the domestic relations affidavit did contain estimates of the current expenses that Ms. Larson was incurring or was expecting to incur, and that shows that there was only a need of $1,245 a month, which is less than the $2,500. However, those expenses, again, were estimates based on the fact that Ms. Larson is in the marital residence, that she has not been the one who has been responsible for the finances during the parties' relationship. And so she was attempting to make those estimates based on what little information that she was able to gather on her own. However, notably, the expenses do not include a rent expense, for example. Ms. Larson is the parties are going to be selling the marital residence, so Ms. Larson is going to be incurring some form of expense in order to live in her own place. It doesn't have a health insurance expense because she's currently covered under Mr. Larson's health insurance. There are a number of expenses that are not incurred or not included in the DRA because they're just unknown or haven't been incurred yet. On the flip side, Mr. Larson can easily afford to pay the $2,500 a month that we requested. Based on his domestic relations affidavit, it looks like he has a net balance of $20,908 a month after payment of his expenses. We're asking for $2,500 a month to help support his spouse. We believe that it is not inequitable to ask Mr. Larson to support his spouse. They've been married since 2011. This is a relatively long-term marriage. And Ms. Larson has not worked since 2012 by agreement of the parties. She has remained at home. She does not, I mean, to say that it's just easy to go out and find employment with everything that's been going on the last couple months for Ms. Larson, I don't think that that's fair when she's been out of the workforce for over a decade, and Mr. Larson has been the sole caretaker financially for her. I don't think that it's fair that Ms. Larson should have to depreciate her half of the marital estate in order to support herself when Mr. Larson has more than enough finances to not only support his spouse, but also to continue to grow his half of that marital estate significantly. Again, as I noted, his income is sizable. With regard to the investment accounts, Ms. Larson was aware that there were investment accounts. She did not know that it was paying out dividends. And I think that was the point I was attempting to make in my response if that didn't come through. She found out recently about the dividends, but it's not because she actually received them. In fact, Mr. Larson sent a text message through the party's daughter stating that the dividends are paid out periodically throughout the year. And as he said, I'm quoting here, these dividends were from the Brazilian oil stock that Heather knows about and even said she wanted the stock from it at one point. The dividends we had go back into buying more shares of the stock minus the taxes we owed on the dividends. These amount of dividends last year was $115,656, $57,828 each, $4,819 each month average paid through the year. His theory is that because there was $4,819 each month on average throughout the year last year, even though that money didn't actually go into the party's account, it was either spent on taxes or reinvested, that this is now going to be imputed as an income to Ms. Larson. And again, I'm taking Mr. Larson's own words here. I'm not relying on what Ms. Larson is telling me. So his position is that because there is theoretical income through these dividends, even though Ms. Larson doesn't actually have access to them because they've been reinvested.
Ms. Thompson just related to the court that your client does have access to those funds and could withdraw those at her discretion.
She doesn't, what I'm saying is she doesn't so in the sense that she has access to the funds that had been in existence prior to the filing of the divorce, yes, in the same way that Mr. Larson has access to those funds. In the sense that she's receiving a check in the mail for these dividends that she can utilize on her own expenses, that is not correct because there are no dividends being received. The dividends that were received were reinvested, and no dividends have been issued since then to Ms. Larson's knowledge. Now, if they have been issued, they've been issued into an account that she's not accessing because typically speaking, we ask that the parties not depreciate the marital estate until final orders of the court are issued, including bank accounts, investment accounts, retirement accounts. And so Ms. Larson is not depreciating those marital assets. Instead, she is asking that her expenses be supplemented by Mr. Larson's income, which is significant and has been used to support her as his spouse throughout the entirety of the marriage. This is, in my opinion, a classic example of a situation where spousal support is warranted when one party has a disproportionate amount of income, the other party either has little income or in Ms. Larson's case at this point, zero actual income that she could spend that is coming in on a monthly basis. That's what spousal support is for. Again, if the court were to order that she dip into the marital estate to pay for her expenses, we would just ask that be not taken out of her half of the marital estate. If that's the proposal, they could come out of the full amount, as well as the money that goes back into the estate while this case is pending should be considered as well as increasing the value of the marital estate. Because what really Ms. Thompson is asking is that Ms. Larson reduce the marital estate while Mr. Larson builds up himself a nice little nest egg with the significant amount of income that he's going to be receiving while this case is pending. And we're not asking that he pay hardly any of his disposable income when it comes to this. I mean, it's a little more than 10% of his disposable income, not his gross income, but his disposable income is being requested for spousal support. I just frankly think that the asking to not have to pay anything under these circumstances is frankly ridiculous.
Mr. Andrews, would you support this court reducing spousal support on a temporary basis in light of what your client's estimates of actual expenses are at this juncture?
As long as the court is willing to re-increase it once her expenses increase within the next 30 days, when she's no longer able to live at the house that doesn't have a mortgage on it.
Your Honor, may I address that point?
You may.
The parties were asked, specifically Ms. Larson asked to go ahead and put the marital home up for sale. It is not closing anytime soon, so the argument that she's going to be needing rent is just not necessarily, it's something that she's causing of her own accord. So I don't believe that the court should consider that as why she needs spousal maintenance.
And Your Honor, I would just respond briefly that the parties have brokered an agreement through an auctioneer to auction the house, and she has to vacate by September 23rd.
Sorry, my client was not aware of that or informed of that, and so we do not know of the auction.
Well, according to McCurdy Auctioneer, they've been in contact with them and they agreed on a price and they agreed on a date. So unless McCurdy Auctioneer is providing incorrect information,
I think they needed to
that's
contact your client first, that's all. And so that's why they didn't have a date to give to my client.
All right. Ms. Thompson, anything further to present to the court at this time?
Your Honor, I just would point out that my client's income is sizable, but he doesn't have a specialized degree. And I know that Ms. Larson doesn't have a degree, and so she is just as capable of going out and earning money during this time. And I think the court needs to take that into consideration. And one final point on the health insurance, that's obviously not going to be a concern at all until this divorce is finalized, because we are not asking for her to be removed from the health insurance, and she can't be removed at this point. So I don't believe that should be considered as well. And there is no check that goes out to either party on the dividends. It goes directly into that account, and she has access to that account and should be able to see those deposits.
Very well. Any last words, Mr. Andrews?
I guess I would just make inquiry if Ms. Thomas knows when the last time there was a deposit into that account. I'm sorry, I said Thompson, I meant Thompson. I apologize for.
According to my client, Mr. Larson, it would have been about 2 months ago, and so there should be another one made soon.
And so again, my understanding is the amount 2 months ago was the amount that was reinvested. So there hasn't been
any reinvestment since 2023 in the first quarter of 2023.
That's not what Mr. Larson told his daughter.
Well, then that's what I'm telling the court today at this hearing.
All right. Very well. Thank you, counsel. Appreciate the quality of your arguments here today, and the court has had the opportunity to review the contents of the file in this case and to consider the temporary spousal maintenance order in this case. The court will make the observation that, generally speaking, the court looks at the need of one party for spousal maintenance and the other's ability to pay. Here, there's an obvious large disparity in income between the parties. And the court has also considered the fact that the parties do have assets that are at this point liquid enough that could be accessed. However, I do understand Mr. Andrews' argument and agree to a certain extent with it that depleting assets of the marital estate just for purposes of everyday needs does not make sense to this court. Further, the fact that Ms. Larson doesn't have a job at this early juncture in the case shouldn't be surprising. She wasn't working during the term of the marriage, and while the court would look at her employability for long-term spousal maintenance in this case, the court looks at the issue of temporary spousal maintenance is just a question of cash flow. Both parties need cash flow to keep functioning during the pendency of this case. It's intended, as Ms. Thompson recognizes, to be transitional and at this point, temporary. The court, looking at the expense that are listed by Mr. Andrews and his client, will find that a reduction in spousal support is called for under these circumstances, and the court will order retroactively that the spousal support in this case be set at $2,000 a month, effective with the first payment, which the court also modifies to July the 14th. This was a week after service in this case, and it was a realistic date for payment in July. He would owe for August, and we'll have another payment due September the 14th. Therefore, at this point, $4,000 of spousal support has accrued. Only $2,500 has been paid. The court directs and orders that Mr. Larson, as soon as possible, remedy the deficiency in this case by paying an additional $1,500 to Heather in this case as temporary spousal maintenance. All right. With those rulings made, Mr. Andrews, are you seeking additional relief at this time?
Not at this time, Your Honor.
Ms. Thompson, anything further at this juncture?
No, Your Honor.
How is your client, how did he pay the first installment of $2,500? Did it go to the Kansas Payment Center?
It did, Your Honor.
All right. Then I would expect that this $1,500 arrearage, which the court has established today, be paid through the KPC as quickly as possible.
Yes, Your Honor.
All right. I ask the parties to continue to exchange information and work together with the prospect of perhaps resolving the issues in this case. Short of trial, if the parties need the court to schedule some sort of status or conference at this time, the court will do so. Mr. Andrews, are you requesting that?
Not at this time, Your Honor. I've issued some informal discovery requests to Ms. Thompson. She's provided a number of documents. I just received them. I have not had the opportunity to go through them yet to determine if I've got everything I need or if I still need some more. But I don't have any reason to believe I don't have everything I need. I just don't know for sure. So once I had a chance to do that, I think that right now we're working really well at getting everything we need information-wise, and hopefully be in a position to start submitting settlement proposals to each other here in the very near future.
All right. Ms. Thompson, are you seeking any settings be made on the court's calendar at this point?
Not at this point, Your Honor.
Mr. Andrews, if you'll draft an appropriate order amending the temporary order on spousal support in accord with the court's orders made here this afternoon.
Yes, Your Honor.
And if there's nothing further at this time, the Larson matter will be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
Before this hearing even truly gets underway, we're already stepping into a classic courtroom battle over temporary spousal support, and it's about to get intense. One side claims the wife has access to tens of thousands of dollars in dividend income, while the other argues she's been out of the workforce for over a decade and suddenly left without real income. The judge now has to answer a crucial question: should a spouse rely on marital assets, or should the higher-earning partner keep paying support? Let's break down exactly what happens. Now, this is where the husband's argument becomes particularly aggressive from a legal standpoint. His attorney lays out 4 key points. The wife's listed expenses are relatively low. She has access to nearly $50,000 in joint accounts. She hasn't actively sought employment, and most importantly, there's a large investment account generating dividends. In family law, this raises a fascinating debate. Should someone receive spousal support if marital investments are already producing income? Or does forcing someone to use those assets unfairly erode their share of the marital estate before the divorce is finalized? Things get even more complicated when the discussion turns to those investment dividends from Brazilian oil stocks. The husband's side claims the account produced nearly $115,000 in dividends last year, averaging roughly $4,800 per month, which would theoretically cover the wife's entire budget. But the wife's attorney pushes back hard, arguing that those dividends were reinvested or used for taxes, not distributed as usable cash. This distinction matters enormously in family court, because theoretical income from investments isn't always treated the same as actual cash flow someone can spend, and in the end, the judge delivers a balanced but decisive ruling. Instead of eliminating spousal support entirely, the court reduces it from $2,500 to $2,000 per month and makes the order retroactive to mid-July. That also creates an immediate $1,500 payment deficiency the husband must pay right away. This decision shows how courts often try to strike a middle ground, acknowledging the husband's arguments about available assets, while still recognizing the wife's financial dependence after years outside the workforce. But now we want to hear from you. Did the judge make the right call reducing the support instead of eliminating it? Or should the wife have been required to rely on the investment income instead? If you found this case as shocking as we did, hit like, drop your opinion in the comments, and subscribe for more intense courtroom breakdowns.